If you didn't gather from my 30-second presentation, which I thought went really well, I'm not a handyman. I'm a lawyer, and I do estate planning. There are things I'm good at. I'm here for a reason. And today I'm going to talk about probate. I talk about it in a lot of my 30-second presentations. I talk about probate and why I want to talk to people about probate. But a lot of times, like, what is this? Why is it so important? Again, a little bit about me. We covered all of this, and this is what you really want to know. This is why I do what I do. This is why I get out of bed. This is my little guy. This is Luke, and that's my wife, Amy, and him standing by a reindeer. He was super loving Christmas. First question that people always ask: what does probate mean? I mean, if you trace back the definition of probate, it comes from the Latin word probatum, which means something conclusively proven. And yes, I just referred to the Latin. I mean, when was the last time any of you referred to something in Latin? Get on my level. But what are we conclusively proving? What we're proving is that the document that's presented is in fact the individual's last will and testament. The document that you signed when you got with hopefully a lawyer and not LegalZoom and completed it and signed it, that it was signed correctly, that it was witnessed correctly, and that you haven't updated or changed it or made corrections to it, that what's presented to the court, this is that individual's intent. I want this to be my last will and testament. And now we use the word not just to prove the will, but we also usually use it to include all the estate administration, which comes after we prove the will. What do we do next? Why is the will so important? The will is the roadmap. The will is what decides how do we go through the estate process. It governs, it's the rule book for where does my stuff go, who gets my stuff, who watches my kids after I die, am I setting up a trust, who's responsible to carry all these things out. The will is what sets all these things out. Everybody technically has a will if you never actually bothered to do your own. The state gives you one, which is just sort of a set of default provisions that they say if you don't want to state your intentions, then we'll just declare your intentions for you. I could do a whole 8 minutes and probably will at some point on what comes into those default provisions, because there's I think some poison pills in here that you wouldn't want. But the state also allows you to overwrite all of those rules, and that's what your will is. So if you sign a will, you get to throw out everything that the state gives you and say, this is what I want to do. These are the things that I want controlling. So what is the probate process? What happens after somebody dies? I mean, it really kind of comes into a couple of steps. The first step is we open up the estate, and I put in there boring lawyer stuff, because there's a lot of technicalities. You open up an estate by filing a petition to probate will. There are a lot of technicalities in there. Certain people have to be noticed properly. Some people do, some people don't. And if you don't do that correctly, you're going to get a love letter from the judge saying you screwed that up, and I want you in my chambers to talk about this, which most people freak out about, and that's what I get called into a lot of times. Once that's done correctly, and the court accepts the will and declares that the individual named in there as the executor sends out what's called letters testamentary, then that person is in charge and can move on to actually, this is the estate administration part. We're really handling three things. Gather all the assets, you pay off all the debts, and you distribute what's left to the beneficiaries that are either named in the will or defined for you by the state. I get dry mouth. Once all these things are taken care of, we close out the estate. And again, I say more boring lawyer stuff, because this is the part where I come in and write letters to the heirs or beneficiaries to make sure that everybody has the information that they received, that everybody signed off properly, and do the discharge petition. And this sort of lays out, these are the things that I generally handle in an estate. When I say what's a typical estate, these are the estates where everybody gets along. These are the things where people aren't challenging and these people aren't fighting. Normally what I handle, these are just the legal aspects of dealing with an estate. I file the petition to probate will or letters of administration. If they didn't have a will, I file the notice to debtors and creditors. I get the EIN for the estate. I give advice to the executor on how to deal with things, on assets, on record keeping, on how the distributions that should be made or when they should be made. And again, once everything's completed, I'll come in and I'll file the petition for discharge. Again, this is sort of my typical run-of-the-mill average will. And you may be saying, why do you spend so much time advertising it? This doesn't seem like, that you would make very much money off of that. And a lot of times, it's very, very straightforward. It's very simple. But sometimes things go wrong. And these turn good clients into great clients for me. What are the things that go wrong? Really, the things that we're looking at is conflict. A lot of times, probate would be really easy if it didn't include two things, and that's people and money. You put those two things in a room together, and you're going to start coming up with issues. And we come up with problems on every one of these areas. When we're opening up the estate, I'm dealing right now with a client where we're challenging the individual that was named in the will because, this is just a great story, mom spent the last 6 weeks of her life in a hospital bed. That's where she died. 2 weeks before she died, one of the kids used their power of attorney to go and update beneficiary designations, to bring in a new will that none of the other kids knew about. We changed life insurance, we changed 401k, we changed POD designation on some different accounts, and we're finding out about all of that right now. So yes, we are challenging who the will named because this, and shockingly, all of these things resulted in them receiving more money than she originally set up in those. So we're challenging that. When you're looking at gathering assets, a lot of times there is a debate over what actually belongs in the will. You get property that's designated a certain way, and when you get things that say 50% goes to this kid, 50% goes to that kid, and then we're fighting over what does that 50% include? Does the house that they receive as joint tenants with right of survivorship, does that include as part of their 50%? Is that money towards them, or is it not? Do they get half of everything? When we're paying off debts, there comes into a lot of situations where I have another will where it says, my Wells Fargo account goes to this individual and my Bank of America account goes to this individual, but the executor paid all the debts of the estate out of the money that was in the Bank of America account. It's always just amazing to see the way people kind of like finagle things. So what it comes down to at the end of the day is, can you handle this yourself? Sometimes. If something blows up, if somebody's causing problems, if somebody's raising issues or concerns, or you're the beneficiary of one of these states and you have issues or concerns, don't try to deal with this by yourself. Josh Shirley, Shirley Law Firm.